There are things that happen inside courtrooms that the public never hears about, not because they are hidden exactly, but because the legal process is slow, the records are dense, and the people involved are often constrained in what they can say and when they can say it. Cases move through systems, documents accumulate, and by the time the full picture becomes visible, the news cycle has moved on, and most people have forgotten that the story existed. This is not one of those cases. This is a case where what happened inside a courtroom became impossible to contain. Not because someone leaked it, not because a journalist broke it open, but because a federal judge put it into a public record with the kind of language that does not require interpretation. The man at the center of it was a sitting United States congressman. His name was Representative Dale Whitmore. He had served 3 terms in the House, represented a district in the Mid-South, and had built his political brand on a platform that his campaign materials described, consistently and without irony, as accountability and the rule of law. He is no longer in Congress. What happened between those 2 facts is the story. Dale Whitmore had come to elected office through a path that was, in the context of American politics, unremarkable. He had practiced law for 14 years, built a regional reputation as a tough negotiator in civil litigation, and transitioned into politics in his mid-40s with the combination of professional credibility, personal ambition, and a district-level name recognition that made him a viable candidate in a year when the incumbent was vulnerable. He won by 11 points. He was re-elected twice, the second time by a wider margin. He was not a prominent national figure. He was the kind of congressman who worked committee assignments, cultivated relationships with local donors, and understood that longevity in office was the product of 1,000 careful decisions made over years rather than a single dramatic moment. He was careful. He was deliberate. He was, by the assessment of people who worked with him and for him, intelligent enough to know exactly what he was doing at all times, which is what made what he did so difficult, initially, for people to believe. The civil case that brought Whitmore into contact with the federal judiciary was, on the surface, a business dispute. A technology company based in his district, a firm called Crestline Data Services, had been sued by a former partner over a contract termination that the plaintiff alleged had been improperly structured to deprive him of a significant equity interest. The case had been in litigation for 2 years and had reached a stage where a summary judgment motion was pending before a federal district court judge. Whitmore had no formal role in the case. He was not a party. He had no legal standing in the proceedings. He did, however, have a financial relationship with Crestline that had not been publicly disclosed. Not a direct investment. That would have been traceable in ways he understood were traceable. What he had was something more diffuse, and therefore, in his calculation, safer. A consulting arrangement, structured through a third-party LLC that had paid him approximately $400,000 over the preceding 3 years for services that were described in the contractual documentation as strategic advisory on regulatory and government relations matters. In plain language, Crestline was paying a sitting congressman through a shell structure for access and influence. This was not in itself the crime that ended his career. It was the context for it. The judge assigned to the Crestline case was the Honorable Renata Voss. Judge Voss had been on the federal bench for 14 years. Before that, she had spent 9 years as a federal prosecutor with a specific focus on public corruption and financial fraud. She had put people in prison, not abstractly. She had built cases, stood in courtrooms, presented evidence, and watched juries deliver verdicts that sent people who had believed themselves beyond reach to federal correctional institutions. When she moved to the bench, she brought with her a particular sensitivity that is hard to acquire any other way. The ability to recognize, early and precisely, when someone is attempting to use a legal proceeding as a vehicle for something other than justice. She had been a judge long enough that most of the attorneys who appeared before her understood this. Those who did not learn it quickly. Whitmore did not appear before her. He sent an emissary. The contact came through a man named Robert Feely. Feely was a Washington-based political consultant and lobbyist who had worked with Whitmore since his first campaign. He was not an attorney, had no standing in the Crestline case, and had no legitimate reason to contact a federal judge about a civil proceeding in which neither he nor his client had any formal role. He requested a meeting through Judge Voss's chambers, identifying himself as a representative of interested parties and characterizing the meeting as a brief informational conversation. Her clerk declined on her behalf, noting that ex parte communications regarding pending cases were not appropriate. Feely sent a letter. The letter was carefully worded in the way that letters written by people who understand they are doing something inadvisable tend to be carefully worded. It did not use explicit language. It referenced the importance of the Crestline case to regional economic development. It noted Representative Whitmore's long-standing interest in the district's business community. It suggested that a resolution of the case favorable to Crestline would be viewed positively by parties with significant influence over federal court funding allocations. That last sentence is worth reading again. A favorable ruling would be viewed positively by parties with influence over federal court funding. It was not written as a threat. It was written as an observation. But the observation had only one possible meaning: rule in our favor, and people who control resources you depend on will remember it favorably. Rule against us and draw your own conclusions. Judge Voss read the letter once. She called her clerk. She asked for the letter to be scanned and preserved. She asked for the original to be sealed. And then she made 2 phone calls, one to the chief judge of her circuit and one to the Department of Justice's Public Integrity section. She did not respond to Feely. She did not need to. What followed was a federal investigation that ran for 7 months before any of it became public. The FBI interviewed Feely early and without forewarning. He retained an attorney within 48 hours and, following several sessions in which his attorney and federal prosecutors had the kind of conversations that experienced lawyers have when the underlying facts are not in their client's favor, he agreed to cooperate. His cooperation provided documentation of several things that investigators had suspected but could not previously establish. The structure of the LLC through which Whitmore received payment from Crestline, the communications between Whitmore and Crestline's executives in the weeks before Feely's letter was sent, and 2 phone calls, recorded with Feely's cooperation, in which Whitmore discussed the outcome of the federal case in terms that made his interest in it explicit. In one of those calls, Whitmore said something that would later appear in the federal indictment as a direct quotation. He said, "Judges don't operate in a vacuum. She needs to understand what kind of attention this case is getting." He was talking about Judge Voss. He was in the terminology that federal prosecutors use when they file documents in cases like this, attempting to corruptly influence a federal judicial proceeding. The indictment was filed on a Tuesday morning. By Tuesday afternoon, Dale Whitmore had retained the most prominent federal criminal defense attorney in Washington. By Tuesday evening, he had released a statement describing the charges as politically motivated and legally meritless, and expressing full confidence in the justice system he had spent his career championing. The arraignment was held in the same federal courthouse where the Crestline case had been pending, though before a different judge, reassignment being standard procedure when a case involves potential judicial contact. Whitmore appeared in the kind of suit that a man wears when he understands that the photograph taken outside the courthouse will be published widely and wants to project through his clothing the message that he is calm, legitimate, and not afraid. He was composed. His attorney was composed. The appearance lasted 12 minutes and was procedural. Outside the courthouse, a cluster of reporters asked questions that his attorney deflected with practiced fluency. Whitmore himself said nothing beyond a brief prepared statement, reiterating his confidence in the process. He looked like a man who had been through difficult situations before and expected to navigate this one. He had been through difficult situations. He had not been through this one. There is a particular challenge in prosecuting public corruption cases involving sophisticated defendants. The sophistication works both ways. These are people who understand how legal proceedings function. They retain experienced counsel. They know which arguments to make and in what sequence. They know how to characterize intent, or rather, how to make intent ambiguous enough that reasonable doubt becomes a possibility. The federal prosecution team assigned to Whitmore's case was aware of this. They had built their case around documentation rather than interpretation. The LLC structure was documented. The payments were documented. The communications were documented. The recorded calls were documented. Feely's testimony was documented. What they had was a paper record of a series of decisions that, taken individually, might each be characterized as something other than what they were. Taken together, they were difficult to characterize as anything other than what they were. The jury trial lasted 11 days. Whitmore's defense team made the available arguments with skill. They challenged Feely's credibility as a cooperating witness with his own legal exposure. They characterized the LLC arrangement as a legitimate consulting structure that had been misconstrued. They argued that the phone calls, taken in context, reflected political frustration rather than criminal intent. The jury was out for 2 days. The verdict was guilty on 3 counts: honest services wire fraud, attempted obstruction of a federal judicial proceeding, and failure to disclose a financial conflict of interest as required under federal ethics statutes. The sentencing hearing was held 4 months after the verdict. This was the proceeding that became, in the weeks and months that followed, the part of the story that people returned to most often. Whitmore's attorneys submitted an extensive sentencing memorandum. It detailed his years of public service, his community contributions, the impact of a custodial sentence on his family. It included letters from colleagues, constituents, and community figures describing his character and the contributions he had made during his 3 terms in office. It made the case, with professional thoroughness, for a sentence at the lowest end of the applicable guideline range, or below it. Before the judge delivered the sentence, there was an opportunity for the defendant to address the court. Whitmore took it. He spoke for approximately 9 minutes. He expressed remorse, measured, carefully worded remorse that his attorney had clearly reviewed. He acknowledged that his judgment had failed him. He spoke about his family. He spoke about the district he had represented and the work he believed he had done for it. He said that he understood the gravity of what he had done and accepted responsibility for it. It was the most carefully calibrated 9 minutes of his career. The judge presiding over the sentencing was not Judge Voss. She remained recused from anything connected to the Crestline matter. The sentencing judge was a man named Judge Thomas Caraway, who had been on the federal bench for 23 years and who was known in the legal community for sentences that were proportional, considered, and unaffected by the profile of the defendant. He listened to Whitmore's statement in its entirety. Then he spoke. Judge Caraway began not with the sentence, but with an observation. He said that in his years on the bench, he had encountered many defendants who expressed remorse at sentencing. He said that the quality of remorse was not something he could assess with certainty from the outside, and that he tried not to make determinations about the sincerity of what defendants communicated in that moment. But he said something else. He said that one of the obligations of sentencing a public official convicted of public corruption was to consider not just the individual before the court, but the effect of that individual's conduct on the institution they had served and on the public's trust in that institution. He said, Representative Whitmore did not simply exercise poor judgment in a moment of pressure. He made a series of deliberate choices over a period of time that reflected a belief that his position placed him above the obligations that apply to every other citizen of this country. He attempted to use the levers of political power to influence the outcome of a federal proceeding. He did this while serving in a body whose constitutional function includes oversight of the very judicial system he attempted to corrupt. The message that a sentence in this case sends is not only to Mr. Whitmore, it is to every person who holds public office and is weighing, as they will inevitably be weighing, whether the rules apply to them. He sentenced Whitmore to 42 months in federal custody, to be followed by 3 years of supervised release and a fine of $250,000. The room absorbed the number in silence. Whitmore's attorney immediately noted his intention to appeal. Whitmore himself sat very still. The man who had built a career on the phrase accountability and the rule of law sat in a federal courtroom and received the accountability and the rule of law. The appeal was filed. It was heard. It was denied. The specific legal arguments made in the appeal and the court's reasoning in denying them are part of the public record and available to anyone who wishes to read them. They are not, in the essential sense, the point. Whitmore reported to federal custody in the spring following his sentencing. He served 31 months of his sentence before becoming eligible for and receiving early release. His law license, which had been automatically suspended at conviction, was subject to a reinstatement process that requires, among other things, a demonstration that the attorney has been rehabilitated and is fit to practice. As of the time this story became fully public, that process had not been completed. His congressional seat was filled in a special election. The candidate who won described her platform as a return to genuine public service and ethics in representation. She won by 17 points. Judge Renata Voss continued her work. She did not speak publicly about the case. She was not asked to testify during the trial. Her actions had been correct, immediate, and fully documented by the letter itself and her report to the chief judge, and nothing further was required of her. She appeared in the trial record as the intended recipient of the corrupt influence, and in that record, her conduct is described as exemplary. What she did on the day she received Feely's letter was the correct thing. It was not a heroic thing, in the sense that it required unusual courage. It was, in the most straightforward sense, exactly what a federal judge is supposed to do when someone attempts to corrupt their proceeding. Report it, preserve the evidence, continue the work. The heroism, if that word applies, is in the ordinariness of it, in the fact that what she did was not dramatic or performative. She read a letter that was meant to intimidate her, and instead of being intimidated, she picked up the phone and began the process that would end a congressional career. She then, to the extent possible given the recusal requirements, continued doing her job. Robert Feely cooperated with the government and received a reduced sentence of 18 months, suspended with 5 years probation, for his role in the scheme. His lobbying registration was revoked. He was barred from federal lobbying for 10 years as a condition of his plea agreement. The Crestline civil case, which had been the original object of the influence attempt, was resolved after the criminal proceedings concluded. The summary judgment motion, the one whose outcome Whitmore had attempted to predetermine, was decided on the merits, without interference, by a judge who had not been contacted by anyone. The ruling went against Crestline on 2 of 3 issues. The case settled shortly thereafter. No one from Crestline was charged in connection with the corruption scheme, though several executives were interviewed extensively by federal investigators. The executives' communications with Whitmore were characterized by investigators as potentially relevant but insufficient for prosecution, without direct evidence of knowing participation in the obstruction plan. The company still operates. It has different leadership. There is a version of Dale Whitmore's story that he might have preferred to be true. In that version, the letter never gets traced back to him. Or it does, but the investigation stalls. Or the investigation proceeds, but the evidence isn't enough. Or the evidence is enough, but the jury doesn't convict. Or the jury convicts, but the appeal succeeds. There are many points in that chain where the outcome could have been different. Legal history is full of cases where it was different, where the sophisticated defendant found the crack in the evidence, or the ambiguity in the jury instructions, or the sympathetic appellate panel. This was not that case. And it was not that case, in significant part, because of what Judge Voss did on the afternoon she read that letter. Because she did not hesitate. Because she understood, immediately and without internal debate, that what she had received was not an observation about regional economic development. It was an attempt to purchase her judicial decision, and she treated it as exactly that, from that moment forward, without equivocation. That is the pivot point of the entire story. Not the verdict, not the sentence, not the appeal. The moment a federal judge read a letter and picked up the phone. Accountability is a word that gets used so frequently in political contexts that it begins to lose its texture. It becomes a slogan, a platform plank, a phrase deployed in fundraising emails and campaign speeches by people who mean it to different degrees and in different ways, and sometimes not at all. Dale Whitmore used it constantly. It was part of his political identity. He talked about holding institutions accountable, about transparency in government, about the obligation of public servants to answer for their conduct. He meant it, presumably, for other people. The thing about accountability, when it functions correctly, is that it does not make exceptions based on who is invoking it. It does not check party affiliation or professional credentials or the persuasiveness of the 9-minute statement delivered at sentencing. It applies to the conduct and the evidence, and it moves forward from there. What Whitmore encountered was not political targeting or institutional bias or a system that had decided to make an example of him. What he encountered was the ordinary operation of a system that he had attempted to corrupt, and that, because of the actions of one judge and the investigators she contacted, did not stay corrupted. The system he had spent his career claiming to champion actually worked. It worked against him because he had put himself in its path. That is not irony. That is the point. There are people who followed this case closely because of what it represented politically, the specific symbolism of a law and order politician convicted of obstructing the law. That symbolism is real, and it matters, and it is not wrong to note it. But there is something else in this story that deserves equal attention. Somewhere in the middle of this case, a man who had served his country in elected office sent a message, through an intermediary, through careful language, through a letter that had been reviewed and considered before it was sent, to a federal judge. And that message said, in the space between its words, we can make things better for you, or we can make things harder for you. And the outcome of this case is the variable that separates those two possibilities. And the judge read that message, preserved it, and reported it. No drama, no press conference, no speech. She simply refused to be the kind of judge that message assumed she was, and everything else followed from that refusal. Dale Whitmore is out of federal custody now. He lives in his home district. He does not make public statements about the case. He does not appear at political events. People who know him describe someone who is quieter than he was, which is perhaps the most that can be said about what happens to a person when the version of themselves they constructed over decades is publicly and permanently dismantled. He is 58 years old. He has time left. What he does with it is not part of this story. This story ends where it ends, with a verdict, a sentence, and a public record that will exist as long as federal court documents exist, describing in precise legal language what a sitting congressman attempted to do to a federal judge and what the consequence of that attempt turned out to be. The record does not editorialize. It does not need to. Judge Renata Voss still sits on the federal bench. She has cases on her docket today, as she has every working day. She has hearings scheduled, motions to review, decisions to write. She does the job the way she has always done it, thoroughly, without performance, and with the specific kind of attention that comes from understanding exactly what the job is and what it is not. It is not a job that adjusts to the people who appear before it. It is a job that requires the people who appear before it to adjust to it. Dale Whitmore thought he could change that equation. He could not. And that single, fundamental miscalculation, the belief that a phone call or a letter or the right kind of pressure could move a person who had spent 14 years as a federal prosecutor before spending 14 more years as a federal judge, turned out to be the most consequential mistake of a career full of careful, calculated decisions. He was careful about almost everything. He miscalculated her. That was enough.